case on alleged snooping by the centre using Pegasus software, the Supreme Court did not mince its words. Referring to the technical report on Pegasus, the court said that nothing that touches the security or sovereignty of the country will be disclosed, but it emphasized that individuals who suspect being snooped upon can approach the courts and get a response. The Supreme Court was hearing the case after a gap of 2 years and said that there was nothing wrong in the country using spyware to protect its security, but the court also would examine allegations of misuse against individuals. The Supreme Court had earlier constituted a 3-member expert committee to probe the snooping allegations against the centre, and the technical report was also submitted in 2022. In its report, the committee had concluded that the spyware was not found in the 29 mobile phones examined by it, according to Bar and Bench. In fact, my colleague Harish joins us on the broadcast to get us more details on this. Harish, very significant remark there coming in from the Supreme Court, the fact that nothing that concerns the sovereignty of the nation will be touched upon, or nothing of that will be disclosed. But at the same time, if any individuals think that it has been misused, the software, then they can still approach the courts.
Yes, that's right, Ashish. In fact, this hearing is resuming after 2.5 years. On the last date, August 2022, the Supreme Court had temporarily closed hearing after concluding that from the 29 devices examined, some kind of malware was found in 5 phones, but there was no conclusive evidence of Pegasus. But now the petitioners, 10 of them, several journalists, activists, politicians, once again knocked the doors of the Supreme Court, citing the December 2024, that is last year, indictment of Israeli company NSO by the US court for, in fact, snooping on 1,400 WhatsApp numbers. 300 of them were Indians. So now these petitioners have come to Supreme Court armed with that. But once again, centre objecting to any roving inquiry once the Supreme Court has closed the investigation, saying that yes, they do legal surveillance in national interest, but there is a protocol for that. That is done after taking requisite sanctions, and denied any illegal surveillance or unauthorized snooping. The Supreme Court found a point in this, saying that there is nothing wrong in using any kind of spyware in national interest for protecting the unity, safety, sovereignty of the country. But yes, we will examine complaints of misuse of the spyware to violating individual privacy, that is misuse against individuals. So for the time being, Senior Advocate Kapil Sibal, who is leading the charge for the petitioners, have been allowed to place on record the US court's verdict against Israeli company NSO, and also circulate it among all these petitioners. So on July 30, that is the next date of hearing, the Supreme Court will look into that particular judgment also. When the Supreme Court made this remark that yes, spyware can be used in national interest, Solicitor General Tushar Mehta made a very interesting remark, saying that now you petitioners should not say that even terrorists have right to privacy. They do not have right to privacy. Even you petitioners are trying to make it seem so. So Supreme Court also taking cognizance of the US court's verdict against the Israeli company NSO December last year, which is the new weapon being used by several politicians, journalists, activists who had approached the Supreme Court. So very significant observation, shot in the arm for the government as far as the Pegasus snooping row is concerned. Back to you.
Absolutely, Harish, like you rightly put it, it is a shot in the arm for the government, especially when it comes to this issue, which was politically as well very significant across the nation. Appreciate you joining us on the broadcast, getting us all those details. And of course, moving